A few weeks ago, we sent out a legal alert to our clients about the new changes in the workers' compensation laws. These are very exciting changes for employers because they, for the first time, allow employers in Queensland to obtain information about an employee's pre-existing medical conditions and injuries, and also obtain information about their previous workers' compensation claims. This can be very useful information for employers to have a very proper understanding and assessment of their ability to perform the essential requirements of the job and do it in a safe way, not affecting their own health and safety and not affecting the health and safety of other people. But this is a bit of a trap for employers because even though they're now allowed to obtain the information, what they do with the information can be a problem. It can be unlawful, and that can give rise to legal claims. And I want to spend some time today telling you about how to avoid those legal claims. Under various discrimination legislation, it is unlawful to discriminate against a prospective employee on the basis of their impairment or disability, or an imputed impairment or disability. There are exceptions to this general rule. So for example, if an employee's or a prospective employee's impairment results in them not able to fulfil the essential requirements of the role, then employers are able to take that impairment into consideration. For example, if you have a position available for a long distance truck driver and you have an applicant who cannot sit for long periods because they have a back condition, then chances are they're not going to be able to perform the essential parts of that role, and you are able to make a decision not to employ them. Other reasons where you might be able to take a prospective employee's impairment into consideration when making your recruitment decisions is where you're wanting to make reasonable adjustments for that employee. So, for example, you might need to make changes to an ergonomic workstation, you might need to make changes to hours of work or roster patterns. Bearing in mind that employers are obliged to make reasonable accommodations for their prospective employees, but not if it's going to create an unjustifiable hardship on the employer. Another reason where you might take an employee's impairment or disability into consideration is where there's a reasonable belief that that person can't perform those particular tasks safely. Now, those exceptions seem fairly simple perhaps to an employer, but they're very technically applied and they're often hotly debated in the context of a legal claim. And I would suggest, particularly in the early days, when employers have information that they're concerned about these pre-existing injuries, these medical conditions, that prior to making a decision based on them, they perhaps get some legal advice just in the beginning so that they can understand the application of these rules. The next thing to consider is in the context of obtaining the history of a prospective employee's workers' compensation claims. The trick for employers in this regard is that if an employer obtains the previous workers' compensation history of a prospective employee and finds that there has been previous claims, and they decide not to employ that person because they've made a claim, then that is probably going to be unlawful behaviour. So these changes are very new for employers. Discrimination complaints, adverse action claims, very expensive for business, very expensive to defend. There's disruption to the organisation. Employers need to now assess their recruitment practices. What are their managers, what are their HR managers asking their candidates? How are they managing information? Employers need to educate themselves about these new laws, get some legal advice in the beginning, and understand how they're going to apply these laws to their advantage. So please always feel free to contact us if you require some information about these matters or any other employment matters.